Hello and welcome to a fresh episode of Legal Wrangle. In today's episode on corporate laws, we will analyze three important recent decisions which would have a long-lasting impact on Indian corporate sector. Let us begin with the first decision of Supreme Court relating to the telecom sector.
In this case, the constitutional validity of the Insolvency and Bankruptcy Code was under scrutiny before the Supreme Court. The primary question that was addressed was whether discriminatory treatment based on intelligible differentia between operational creditors and financial creditors amounts to violation of Article 14 of the Constitution.
Various petitions were filed before the Apex Court challenging various provisions of the IBC which were discriminatory and unfair to the operational creditors. Apart from primary challenge of virus, the petitions also challenged the appointments of the member of NCLT and NCLAT which was contended to be contrary to the Supreme Court's judgment in Madras Bar Association versus Union of India.
Dismissing the petitions, the Apex Court upheld the constitutional validity of the provisions of IBC. The Apex Court held that the discrimination does not hold waters as there is an intelligible differentia which separates the two kinds of creditors. As long as there is some rational connection between the discriminated creditors and the objects sought to be achieved by the legislation, no wrong can be said to have been committed. Most financial creditors, particularly banks and financial institutions, are secured creditors, whereas most operational creditors are unsecured. The financial creditors have specified repayment schedules, and in cases of default, financial creditors are entitled to recall a loan in totality. Contracts with operational creditors do not have any such stipulations. Moreover, the forum in which the dispute resolution takes place is also different. Operational debts also tend to be recurring in nature, and the possibility of genuine disputes in cases of operational debts is much higher when compared to financial debts. Therefore, preserving the corporate debtor while ensuring maximum recovery for all the creditors being the objective of IBC, financial creditors are clearly different from operational creditors.
In its conclusion, the Supreme Court held that there is no violation of the equality provision of the Constitution. With this, let us now continue with the another recent judgment of Supreme Court on the issue of resolution plans filed according to the IBC.
In this case, the Apex Court addressed the issue whether the collective wisdom in commercial decision of Committee of Creditors can be questioned by the resolution of professionals or the adjudicating authorities. To understand the decision in its full glory, let's first appreciate the facts surrounding the case.
The corporate insolvency resolution process of corporate debtors, companies Steel and Power India and Innovative Industries was initiated under the provision of IBC. After the appointment of interim resolution professional and committee of creditors, various meetings of committee of creditors were convened. However, none of the resolution plans succeeded in getting 75% of supporting votes of the financial creditors. The highest voting percentage recorded in case of Kamini Steel was 66.67% and in the case of Innovative Industries it was 66.75%. The voting shares in both the cases were less than prescribed threshold of 75%. The case of Kamini Steel was heard by NCLT Hyderabad, while the case of Innovative Industries was before NCLT Mumbai. While NCLT Hyderabad allowed resolution plan, the NCLT Mumbai allowed the resolution professional to initiate the liquidation process. The appeal from both the cases were heard together. In case of Kamini Steel, the NCLAT held that since voting was under 75%, the plan cannot be approved. As regards the Innovative Industries, the NCLAT confirmed the order of the NCLT to initiate the liquidation process. The issue of approval of resolution plan and initiation of liquidation process came up before the Apex Court.
Both the appeals were dismissed. The Apex Court confirmed the ratio of the NCLAT decision and observed that the action of liquidation process is only avoidable if the resolution plan is approved by a vote not less than 75% of voting share of the financial creditors constituting the Committee of Creditors. After the amendment of 2018 of the IBC, the voting percentage of financial creditors is raised from previous 66% to 75%. It was observed that upon receipt of a rejected resolution plan, the adjudicating authority is obligated to initiate liquidation process. The adjudicating authority is, however, not endowed with the jurisdiction to analyze the commercial decision of the Committee of Creditors, much less to inquire into the justness of the rejection of the resolution plan by dissenting financial creditors. There is a calm period followed by a swift resolution process to be completed within 270 days, failing which the liquidation process is inevitable and mandatory. The commercial wisdom of the Committee of Creditors has been given paramount status without any judicial intervention for ensuring completion of the stated processes within the timelines prescribed by IBC. The legislature has not provided any ground to challenge the commercial wisdom of the individual financial creditors or their collective decision before the adjudicating authority.
In a nutshell, if a substantial percentage of the financial creditors gives approval of the resolution plan, it would be an immaterial if the approval percentage is less than 75%. Anything less than the new threshold would lead to an inevitable outcome of rejection of the proposed resolution plan. If the plan is rejected and the time period for the approval ends, the adjudicating authority is obligated to start the new liquidation process. Let us now move on to our last case, which refers to the recent order of the Apex Court addressing an insurance law issue.
In this case, the Apex Court addressed the issue of a time period from which a surveyor can calculate the depreciation of insured assets on the basis of the sum insured as per the date of policy. To appreciate the question involved, let us understand the factual matrix.
The appellant purchased a Volvo hydraulic excavator, and immediately after the purchase, it was insured with the respondent. The insurance policy was renewed, and after its expiry, the hydraulic excavator was hired and was used at the different locations. It was badly damaged in a fire while it was in use. The respondent was intimated about the damage and was requested to survey the damage and settle the claim. Though the survey was undertaken and the damage was found genuine, but the amount claimed by the appellant was not settled. The surveyor assessed the total loss and held that the excavator was underinsured and accordingly adjusted the claim. The appellant, however, claimed on the total loss and instituted a case before the State Consumer Disputes Readdressal Commission. Finding fault in insurer's computation of depreciation, the State Commission allowed the appellant's plea. On matter being carried to the National Commission, the State Commission order was partially reversed. The matter finally reached the Supreme Court.
Allowing the appeal, the Apex Court held that it was not open to the parties of the contract to dispute that the value of the subject matter was different from the value declared and accepted by them at the time of entering into contract, except in cases where fraud, coercion or misrepresentation of facts is involved. The parties are bound by stipulation of a sum insured. Therefore, the surveyor and the insurance company were not justified in questioning and disregarding the amount of sum insured. Further, depreciation can always be computed, keeping the figure of the sum insured in mind. The court also observed that this was not the case of underinsurance. The surveyor could not have calculated depreciation for a period prior to the date of policy or contract.
In a nutshell, the question of whether depreciation on asset insured must be computed based on the sum insured and the surveyor cannot calculate the depreciation for a period prior to the date of policy was answered in affirmative by the Apex Court. With this, we wrap up this episode of Legal Wrangle. All the cases discussed by us can be found at www.tiolcorplaws.com. If you have any suggestions, please write in at editor@tiol.in. Keep watching TIOL Tube for more such episodes, and thank you for watching.